Madison, how this will take your medicine. Damn, you in worse shape than the national debt is in. Sitting there useless as two shits.
All right, welcome back, ladies and gentlemen. In this series of 2 short videos, we're going to be looking at the question of whether judicial review was intended by the framers of the Constitution. You know, that's part of the question of our course on the whole. And I'm going to make an argument to you in these 2 videos that indeed judicial review was intended, but it was intended as little more than a weak protection of the powers of the federal government relative to the states, and a very weak protection of individual rights against federal intrusions only, or in other words, not against state intrusions of individual rights. These, I think, clear intentions of the framers can be discerned from the votes that they themselves took in the convention. Strong institutions proposed by James Madison for the promotion of the power of the national government and the protection of individual rights against both state and national governments, they were defeated time and again in the convention, and judicial review was actually what was substituted. Indeed, participants in these debates explicitly recognized the effects of the votes that they were taking. The creation of the Constitution that had weak protections for individual rights and preserved really significant powers to the states to resist the federal government and decide on the rights of the citizens themselves. Now, this feature of the Constitution, Madison saw it as a bug, a real fault, but it was in fact an intended feature of the Constitution. It may help to explain Madison's reversal on the question of the necessity of a Bill of Rights for the Constitution. A Bill of Rights would have been superfluous if Madison's preferred institutions had been chosen in the convention, he thought, but it actually became necessary to salvage at least something of his initial plan for the national government. As we're going to see at the end of these 2 lectures, Madison said as much in his speech introducing the Bill of Rights to the First Congress, where he argued that it could provide, the Bill of Rights that is, could provide guidance and fortitude to the federal judiciary under the Constitution as it was actually constructed. But the Constitution as it was actually constructed was not the one he had wanted, as we'll see. So, given that, the debate over the constitutional foundation of Marbury versus Madison is maybe misplaced. The truth is neither what one side says it is, that the Constitution intended to grant significant powers to the court for the protection of individual rights, nor is the truth what the other side says it is, that the Constitution simply left a gap that didn't forbid the court from claiming this power, and that Marshall had stepped into this gap to assert a strong power. Instead, I'm going to make the argument that the Constitution explicitly adopted the institution of judicial review, but, and this is a big however here, but it did so as a grant of very limited federal power. And while the inclusion of the Bill of Rights extended the power of the federal courts in a certain sense, it did so also in a very limited domain, a domain of individual rights protected only against the federal government. Indeed, maybe the proper question to ask is not whether the framers intended judicial review, but what issues did they intend federal judges to review? To ask this question, we're actually going to harken back to the same list that we used in our lectures about Hamilton and Madison. So you can see in this graphic here, the question is, what problems could judicial review address or not address? First, the federal government might violate separation of powers or checks and balances, or it might violate the powers of the states, or sometimes called states' rights, or it might violate individual rights directly. Or the second thing that the framers might have been concerned about is that the state governments might violate the interests of the United States by either usurping the federal powers or damaging each other's interests, or in other words, the interests of their union, or it might violate individual rights directly, those states might. Now, the Virginia Plan, introduced to the convention on May 29, 1787, was designed by Madison to address all 5 of these problems. First, it would have granted a virtually unlimited power of legislation to the United States Congress, creating a truly national government. Or in other words, Madison and the Virginians weren't really that concerned about issue number 1B, because at this point, they didn't see the national government as a threat to the states. In fact, it was quite the reverse. Second, it would have granted to that national government a, quote, negative, as Madison called it, a power essentially like a veto over state laws. So it would have solved issues number 2, A and B, by vesting partially in the legislative, the national legislative, the power, in the words of the plan, quote, to negative all laws passed by the several states contravening, in the opinion of the national legislature, the Articles of Union. And finally, it would have adopted an institution found in the New York Constitution at the time and in some other constitutions with very few slight differences by creating a joint executive and judicial council to review both the laws of the national legislature and the national legislature's exercise of its negative over state laws. So therefore, it would have solved issues number 1, A and C, by empowering what it called a council of revision. It said, the executive and a convenient number of the national judiciary ought to compose a council of revision with authority to examine every act of the national legislature before it shall operate, and every act of a particular legislature before a negative thereon shall be final. Okay, so we're going to cover both of these institutions, the negative and the council of revision. Let's start with the negative over the laws of the states. Madison wrote in his famous letter to Washington, introducing the Virginia plan, that this, quote, defensive power was akin to what he called a, quote, kingly prerogative. But he said it ought to be granted so that the states don't themselves evade and defeat the powers of the central government. Or as he said, so that they don't, quote, invade the national jurisdiction. Or he said, violate treaties, or, quote, harass each other with rival and spiteful measures dictated by mistaken views of interest. So, in a similar manner, it would grant the national government the power to protect rights, he said. And here's the quote. Another happy effect of this prerogative would be its control of the internal vicissitudes of state policy and the aggressions of interested majorities on the rights of minorities and individuals. So again, it would have covered what we're calling issue 2, A, and B. Okay, remember when I spoke directly to you like this in the first videos for our class and asked you to compare 2 different readings by Hamilton and Marshall based on the color codings that I had done? I was telling you something about an argumentative strategy for comparing 2 readings like that by seeing how 2 very similar readings actually used different themes to varying degrees. We could see the different emphasis that they were placing on things, right? So now I'm actually gonna talk to you to ask you to notice something in these lecture videos. Notice the way I'm using evidence. I make a claim, I then use a quote from a text, and then I follow up that quote with an explanation that focuses in directly on a keyword from that quote in order to justify the claim that I had previously made. This is a 3-step pattern, claim, quote, argument, that you're actually going to see in virtually every Supreme Court case that we read. And it's a pattern that I'm going to ask you to use in your exams and in your papers for this class. We'll have other videos over the course of time emphasizing both these 2 skills and many others that I'm going to want you to pick up over the course of this term. But these little asides here in these videos where I speak directly to you are your first opportunity to see those skills in action. Now, Madison was clear in all of his letters and his notes leading into the convention that he wanted an expansive, largely unenumerated power to be granted to this national legislature. And the Virginia plan would indeed have granted the power to, it said, quote, legislate in all cases to which the separate states are incompetent or in which the harmony of the United States may be interrupted by the exercise of individual legislation, and the negative, it's pretty clear, was meant to be part of this expansive power. However, what happened to it? Where'd it go? We know it's not part of the US Constitution as we have. What happened? Well, I'm going to tell you that story. What happened was that a sometimes shifting coalition, bit by bit, defeated the Virginia Plan in the convention. They opted instead for a series of plans put forward by Roger Sherman that came to be known as the Connecticut Compromise. You could see this as a blend of Madison's Virginia Plan with the New Jersey or small state plan. And this coalition began its attack by first enumerating some very specific powers in the central government. Madison had wanted unenumerated powers. They wanted to enumerate the powers. By mid-July, then, Sherman had actually gathered together enough votes for some of his initially unpopular proposals now to pass. So first, the convention voted to give the states an equal vote in the Senate. That meant rejecting one of Madison's proposals, which was for proportional representation in both of the houses of the US Congress. But then here's what's of interest to us. The very next day, the very same coalition substituted an extremely weak version of what's called the Supremacy Clause, which was found in the New Jersey plan. It substituted that in for Madison's negative. In doing that, it ensured that the supremacy of the national law and the boundaries of federal power would actually be policed by state judges, as we're about to see here. Madison had wanted a strong national response to any overstep of state powers. That, again, is issue 2A and B in our outline. But Roger Sherman actually, in his speeches, praised state judges instead in the debate leading up to this adoption of the Supremacy Clause. And he said that they could be trusted, state judges could be trusted to invalidate, quote, any law contravening the authority of the Union. So this, we're going to see, is actually what they encoded in the Supremacy Clause. You'll see it up in front of you now. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. The Supremacy Clause, you can see, put it within the hands of the judges in every state to enforce the Constitution. It insisted that they shall be bound thereby. Madison didn't trust state judges, or for that matter, the states themselves, to observe the proper boundaries on their own power, but the Supremacy Clause, which won, we saw, spoke only about how state judges are bound. So, recognizing that judicial review had been substituted as the mechanism for protecting against state encroachments on the federal power, Madison wrote dejectedly to his friend Thomas Jefferson on October 24th, 1787, and he said, quote, "It may be said that the judicial authority under our new system will keep the states within their proper limits and supply the place of a negative on their laws," but he objects to this, quote, "A state which would violate the legislative rights of the Union would not be very ready to obey a judicial decree in support of them." So he just doesn't think that this institution of judicial review by state judges will have the effect that a negative on the state laws could have. So the convention's reliance on state courts to mark out the boundaries of state and really federal authority, numbers 1B and 2A in our outline from before, that was indeed part of a series of moves designed to make the national government less powerful. And Madison was well aware that he had been defeated on these things, and indeed he was aware that this was a defeat for individual rights as well, since it left no institution to check the incursions of the states upon the individuals. That was issue number 2B in our outline. So it seems clear that the defeat of Madison's plans for a national negative on state action was a conscious move to insert a form of judicial review into the Constitution, but it seems equally clear that it was intended to be a very weak institution indeed. We're going to come back and look at the argument in our second video, the argument regarding the Council of Revision, and we're going to see how this further weakened the national government and contributes to our overall argument about the substitution of judicial review into the Constitution as a very weak institution. I'll see you then.